Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Hope Williams presenting for us. If you are unfamiliar with the format of this event, first, Hope is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum, and Legal Aid is not representing you at this time. Hope will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions. And with all that being said, I'm going to pass it over to Hope to get us started.
Thank you, Marissa. Hi, everyone. My name is Hope Williams, and I am the Interim Director of Legal Aid of North Carolina's Fair Housing Project. And I am happy to be here today to talk to you about reasonable accommodations, which is a protection for people with disabilities under the Fair Housing Act. Before we get into our presentation, I just wanted to say that the work that provided the basis for our presentation today is supported by funding that we get through a grant with the U.S. Department of Housing and Urban Development. But we at Legal Aid are solely responsible for the accuracy of the statements and the interpretations contained in this publication, and that such interpretations do not necessarily reflect the views of the federal government. As Marissa said, the information that we are presenting today is for information and educational purposes only and does not constitute legal advice. So today what we're going to talk about is we're going to have a brief overview of what the Fair Housing Act is. We're going to talk about protections for persons with disabilities under the Fair Housing Act. We're going to talk about what is a reasonable accommodation, which you might see referred to in the slides as an RA. We're going to talk about what is a reasonable modification, which we sometimes refer to as an RM. And we're going to talk about how to ask for a reasonable accommodation or reasonable modification, including what sort of documentation can be used to support your request. And at the end, we're going to be talking a little bit about circumstances when a reasonable accommodation or modification might be denied and what steps you can take to do about that. So to start with, today we are going to be talking about the Fair Housing Act, which is a federal law that applies to housing and protection and housing against discrimination. And there's also a state Fair Housing Act, which is equivalent to the federal Fair Housing Act. And there's a few local municipalities that have fair housing ordinances. That would be Charlotte, Winston-Salem, Greensboro, and Durham. And High Point will be having a fair housing ordinance that is enforceable within the next couple of months. So what is the Fair Housing Act? The Fair Housing Act, as I said, is a law that prohibits discrimination in housing on the basis of a person's protected class. And we're going to be breaking down what some of these terms mean as we proceed through the slides. So what are the protected classes? The protected classes that are covered by the Federal Fair Housing Act, which is really going to be our main focus today, are race, color, national origin, religion, sex, familial status, disability, and in North Carolina's Fair Housing Act, there's also a protection related to affordable housing. So we're going to talk just a little bit about what some of these protected classes cover. So race and color are generally synonymous, but they apply to a person's race or their skin color, and they were part of the original Fair Housing Act, which was passed in 1968. And so if a person is being discriminated against based on being African American or based on their race or ethnicity, that probably would fall under these classes. And with color, sometimes we have seen cases where a person is being discriminated against based on their shade of skin within a skin color. So a person who is lighter skinned or darker skinned may be treated differently. So that could also cover color discrimination. National origin applies to a person's ancestry. So a person who is being discriminated against based on being from a different country or from speaking a different language in housing may have a claim under the Fair Housing Act for national origin discrimination. Religion covers all religions or no religions at all. And so if a person is being discriminated against based on their religion in housing, for example, some cases that have come out under the Fair Housing Act include situations where a person has a religious display in their yard that's during a time of year that in a homeowners association, they're not allowed to have them. For example, the homeowners association allows holiday displays during December because that aligns with Christmas. But a person of another religion wants to put up a holiday display in the spring, for example, because of a religious holiday, and they are told that they can't do that. That could possibly be a form of religious discrimination. Sex discrimination applies to discrimination against people based on their sex. It can be people who are being denied housing because they are a female. That was why the law was passed back in 1974 when the Fair Housing Act was amended. And it's also been expanded to cover sex harassment that occurs in housing. So situations where a person is being subjected to unwanted advances by a housing provider or a staff person at a housing complex. So that can be an example of sex harassment. Familial status is protections for families with children. If families are being told that they can't rent at an apartment complex because there are children, or if there are rules that make it very hard for families with children to reside at an apartment complex, that could be an example of housing discrimination. And disability, we're going to be talking most of the time today about disability discrimination, so I won't go into that right now. And the affordable housing protection under the North Carolina law applies to land use decisions. So if a local government is preventing a developer from developing affordable housing in some circumstances, that may be a violation of the Fair Housing Act. That is outside the scope of our presentation today, but that is a protection under the State Fair Housing Act. So when we talked about the definition or what the Fair Housing Act covers, we want to know, what is discrimination? What does discrimination look like? And so that can be a refusal to rent to somebody based on being in a protected class. So if a person comes to rent an apartment and they're in a wheelchair and the landlord says, sorry, we don't rent to people who use wheelchairs, it's too much trouble, that would be a refusal to rent. Different terms and conditions. Say that person with a wheelchair comes to the apartment to rent, and the landlord says, because you're in a wheelchair, you have to pay an extra deposit because I think your wheelchair is probably going to mark up the walls. And so I'm going to make you pay a deposit at the outset to go ahead and cover that damage that we know that you're going to cause. That would be a different term and condition because other tenants aren't being charged ahead of time an additional fee because they're in a wheelchair. Discriminatory statements can be examples, or advertising are examples of prohibited conduct. So, advertisements that say, people with children should not apply here, or professionals only. That could be, single professionals only. That could be an example of an advertisement that is discriminating against families with children. Misrepresenting availability is similar to refusal to rent. It happens if a landlord, initially shows a person a property and then they realize that they're in a protected class and they tell the tenant, oh, or the applicant, oh, the place is not available anymore. The applicant finds out later that it was still on the market. That's misrepresenting availability. Segregating people with disabilities from people without. So, making people who have disabilities only live in a certain part of an apartment community, for example. Coercing or intimidating or interfering with a person's right to fair housing, that can cover a wide range of conduct that is making it harder for a person with a disability, for example, to live in a housing situation. Harassment, we talked about that for sex harassment, but it can apply to any protected class. And then refusing reasonable accommodations and modifications. We're going to talk a lot more about that. And design and construction requirements. The Fair Housing Act also requires developers of multifamily housing to include certain components in that housing to make it accessible to people. And so that's, again, beyond what we're going to be talking about today, but it's something to be aware of, that there are certain design and construction requirements under the Fair Housing Act. So let's dive into fair housing protections for people with disabilities. So the first thing we want to know is what, under the Fair Housing Act, how do they define disability? Which is important to know because different laws might define disability differently. Under Social Security Act, if a person is trying to show that they are disabled to qualify for disability benefits, there's a different definition that's related to being able to work. But when we're talking about fair housing and the definition of disability, it is much broader. And the goal is, because the Fair Housing Act in general is quite broad, because its goal is to stop discrimination and to make people of, whoever they are and whatever protected class they're in, have maximum housing opportunities. And so, again, the definition of disability is very broad. And what that definition is that it is a physical or mental impairment that substantially limits one or more major life activity. And so what that means in, more simple terms is a person has some sort of diagnosis that is limiting their day-to-day living in some way. And so that it could limit their ability to walk or to communicate or breathing or thinking or interacting. And so, a disability that is impacting someone's day-to-day life is considered a disability under the Fair Housing Act. The Fair Housing Act also includes people who have a history of such an impairment and being perceived as having such an impairment. And the reason for that, again, is that we're trying to stop discrimination. And so if a landlord or housing provider is treating a tenant in a certain way because they are aware that the person used to have a disability, or they think that a person might have a disability and they're treating them differently, that could be disability discrimination under the Fair Housing Act. And the disability definition, or when we're talking about who's protected under the Fair Housing Act, it doesn't just apply to the person whose name is on the lease. It also applies to other people who are in the household and to people who are associating with a person with a disability. And so if a housing provider is discriminating against a guest of a person because that person has a disability, that could be housing discrimination, because you're interfering with the right of the person who's living there to have a guest with a disability. So again, it's very broad because we're trying to stop discrimination against persons with disabilities in housing. So some examples of what is a disability: blindness or other visual impairments, deafness or auditory impairments, mobility impairments, perhaps the person uses a cane or a walker or a wheelchair, mental illness like depression or anxiety, cognitive disabilities like ADHD, AIDS or HIV is considered a disability. It can be, again, we're talking about having there has to be some sort of substantial limitation on a person's daily life activities. Alcoholism is considered a disability, and former but not current drug abuse. And I think the reason for that, sometimes people ask, well, what's the difference between alcoholism and current drug use? Alcohol is not an illegal or controlled substance, whereas drugs are controlled substances. So I think there's a component of the unlawful substance that's being used when Congress came up with these definitions. So we already talked about what kind of discrimination might fall under the Fair Housing Act. But there's some other things that come up with when we're talking about disabilities, and that's that landlords or housing providers should not be asking a person, a tenant or an applicant about if they have a disability or the nature of their disability. That can be discriminatory, just asking those types of questions. There is an exception, and one is that if there is a housing program that is specifically targeting people with certain disabilities, for example, there's a housing program called Housing Opportunities for persons with AIDS, then the housing provider can ask if the person has AIDS or is HIV positive, but that does not open the door to asking about other disabilities. And as we are going to talk about in a little bit, if a person is asking for a reasonable accommodation or a modification, then that person does need to provide some information about their disability to show that they qualify for one. So a landlord might be able to ask about if they have a disability, if that person is asking for a reasonable accommodation. Some other protections for persons with disabilities under the Fair Housing Act. We talked about unlawful statements or advertising. Again, if you have, if you see an ad that says that able-bodied persons only can live at this property, that would be an unlawful statement or advertising. Or, commenting on a person who's applying and them having a disability, making a derogatory statement about a person's disability. Those are types of unlawful statements. There's also, a landlord is not supposed to ask questions when a person is applying unless they are asking the same question of all applicants, and it is directly related to a person's ability to comply with lawful lease requirements. And so if a person is coming out of, if a person is in a wheelchair and they apply for housing and the landlord asks them, can you live independently? But they're not asking that of every single person who applies. That would be discriminatory against that person with a disability. All right, so we've talked a little bit about things that housing providers, can't do, or things that if they do them, they might be discriminatory. But we're going to spend the rest of the time today talking about some affirmative disability protections for persons with disabilities under the Fair Housing Act. And those are reasonable accommodations and reasonable modifications. And the goal of accommodations or modifications are to make persons with disabilities have an equal opportunity to live and enjoy the properties that they are living in or seeking to live in. So let's talk about reasonable accommodations. What is an accommodation, and a little more about how you ask for one. So a reasonable accommodation is a change in the rules, policies, or procedures that a person may need, it has to be necessary because of that person's disability. And if granted, that accommodation would provide full and equal use and enjoyment of the housing. And so there's a lot of little pieces there, and it's always helpful to give an example. So one that comes up a lot in the calls that we get here at Legal Aid is that a person might need an assistance animal, but the landlord has a no pets policy. And so that person would be asking for a change in the rules. They'd be asking for a change in that no pets rule. And they would need to show that having the assistance animal is necessary because of the person's disability, and that by having that assistance animal, they are able to have equal use and enjoyment of the housing that they wouldn't be able to have if they were not allowed to have their medically necessary assistance animal. And we'll talk a little bit more in a few minutes about how to ask for an accommodation, how to document your request. But that is, the big picture of what a reasonable accommodation is. And a person can ask for an accommodation at any point that they need one. They can ask for one while they're applying for housing. They can ask for accommodations related to the application process. They can ask for one during their tenancy, and they can even ask for one when they are facing eviction if the reasonable accommodation could remove the basis for eviction. And here at Legal Aid, that's often when we see cases about reasonable accommodations, is because a lot of people know to call legal aid when they are facing eviction. And when they call us and we start finding out some more information about their situation, we find out that maybe they're being evicted because they have an assistance animal and the landlord says that that's a violation of the pet rule, for example. And so we might be able to help them get that reasonable accommodation because that would remove the basis for eviction. So it's important to know that an accommodation can be requested at any time. And typically, a person who needs the accommodation is the one who is asking for it. So the tenant is asking for it on their own behalf. But a person can also have someone else make that request on their behalf. So a family member could ask for it, a social worker or a therapist or a doctor or attorneys. Often we are asking for reasonable accommodations on behalf of our clients, especially if they are facing eviction, for example, or they have tried to ask for one on their own and their landlord seems to be wrongfully denying it. So a few examples of common reasonable accommodations that come up. And I'm not going to say that this is a completely exclusive list. There are, really, there can be an accommodation for all sorts of situations that a person with a disability might encounter where they are not able to fully enjoy their property. But these are some that we see um, with some more frequency. So a big one that we see are people who have mobility impairments and need a change to the parking policy. So a lot of apartment complexes have first come, first served parking, and a person with limited mobility may have to park far from their apartment, and it may be challenging for them to get to their apartment unit. Or it could be that there's assigned parking that's not close to the unit and they need something assigned closer to their front door. So that's in a type of accommodation a person can ask for. Like I mentioned, sometimes people might need an accommodation during the application process. So a person with a cognitive disability may need some assistance with filling out applications. A lot of landlords have online applications now, and perhaps a person with a disability may need a application in a different format or need to have someone fill it out for them. So again, a person could ask for an accommodation related to how to apply for the property. Due date on the first of the month. Sometimes people with disabilities who get SSI or disability payments, those payments come in the middle of the month. That's not something that the tenant can control. It's something that the federal government schedules payments to come out, periodically during the month. And a person gets their payment usually on the same day of each month, but it's not going to be the first of the month, right when rent is due. And so in some circumstances, a person may be able to get an accommodation to move their rent date to correspond with when they are receiving their disability payment. So they're not getting charged late fees every month. Another big one we see are tenants who need to move to a first floor unit because of a disability. Sometimes this is a mobility limit related disability that comes up over time. And they can no longer climb the stairs without risk of injury because of their disability. But they're in the middle of their lease term and their landlord is saying that they can't move because they're in the middle of the lease, or there may be fees involved with moving to a first floor unit. But the reason the person is moving is not because it would be convenient, but it really is because of a disability related reason. And so getting to move, in the middle of the lease and and in many cases, getting those fees waived could be an accommodation. How rent is paid. If maybe a person has a mental health disability or a physical disability that makes it very hard for them to pay their rent check every month, or their money order in person, um, or they have trouble remembering it, and the landlord has a policy that you have to pay by check. Perhaps an accommodation could be to set up a direct deposit or have a representative pay for the tenant to be able to pay that rent. Um, Early termination, that's similar to moving to a first floor. If a person has to move out entirely because they can no longer access or safely access the property that they're living in, they may be able to seek an accommodation to terminate the lease early and to avoid the fees that sometimes are related to that. And we'll talk a little bit more about this because a landlord can deny an accommodation request if it would cause an undue financial and administrative burden. So anytime we're talking about money related accommodations, the landlord may have a basis to say that granting that accommodation would be undue financial burden, but we'll talk about that more in a little bit. Adding occupants to the lease. Sometimes a person may need a live-in aid and they may need to add occupants to their household. Sometimes we've had people who are facing lease termination due to poor housekeeping. Sometimes housing providers do, annual inspections or inspections every few months to make sure the person is complying with housekeeping requirements. And due to a disability, the tenant is having challenges with meeting those expectations. So sometimes some accommodations could be made. It could be for physical reasons that a person is physically unable to keep a house clean up to the standards required, or maybe there are some mental health disability related reasons. And so there could be accommodations to give a person more notice about that, or give them more time, or come up with a plan to address it in stages. So like I said, there's not always one answer for a situation. It's what's going to work for the person with the disability. If they need that accommodation. And we already talked a little bit about the pet rules, so I won't get into that now. I'm going to talk about reasonable modifications for a minute. So we've been talking about accommodations, which is a change in a policy or a practice or a rule. When we're talking about reasonable modifications, we're talking about a physical change to a property that allows a person with a disability to fully use and enjoy that dwelling. And it could be to the interior of a unit, or it could be to the exterior or to common areas. So some common examples that we see are a person may need to install a grab bar in the bathroom. They may need the doorway widened so a wheelchair can go through a doorway, installing a wheelchair ramp, the positioning of a light switch or thermostat or electrical outlets may need to be moved. So a person who is in a wheelchair or has other disability related mobility limitations can access those. Installing a flashing smoke detector or doorbell for a person who is hearing impaired and can't hear those warning sounds or that doorbell. Installing lever door handles for a person who may have problems grasping a standard door handle. So those are all types of modifications. It's changing the physical structure of the property to make it accessible to the person with the disability. So a big thing that comes up with reasonable modifications is who pays for them. When we're talking about reasonable accommodations, it's usually a change in a policy or a practice. And so even though there's going to be that analysis about whether it's an undue financial burden to the landlord, typically it's not things where there's going to be significant costs. But when we're talking about a reasonable modification, there's always going to be some cost involved with physically changing the structure of the property. And so if a person is living in private housing, the tenant is responsible for the cost of the modification. So it needs to be made at the tenant's own expense. And it's important to know that private housing also includes people who are living, who have a housing voucher, a housing choice voucher, but they're living in private property. That is considered private property for the purpose of reasonable modifications. And also low income tax credit housing is also considered private housing for the purpose of reasonable modifications. And so sometimes people are surprised to learn that even if they need something because of their disability, they are going to have to pay for it and not their landlord. So it's important to know that. And sometimes there are programs that are in local communities to help people with building or constructing a modification. And one place I suggest people ask about is a local council on aging. Sometimes those local organizations have information about local resources for a person who needs a modification and maybe doesn't have the funds to pay for it themselves. If a person is in federally funded public housing, which includes public housing complexes and what we call project-based Section 8 housing, or rural housing, these are all federal programs that provide the actual housing itself. In those cases, the housing provider is responsible for paying for the modification unless it will cause an undue financial and administrative burden. And the reason for that is sort of a technical legal reason, but federally funded public housing complexes are also under a separate or have to follow requirements under a separate law called Section 504 of the Rehabilitation Act. And because they're also covered by that law, that is where the requirement to pay for those modifications come in. So it's a little bit of a technical legal thing. But the important thing to know is that if you are in private housing and you need a modification, you as the tenant will be responsible for the cost of constructing and in some cases removing that modification. I mentioned earlier that the Fair Housing Act has some design and construction requirements, and so I just did want to briefly mention that there are some circumstances where if a property was, and what these design and construction requirements include are, there's a lot of them cover things like doorways that are accessible to like go in and out with a wheelchair, and having ramps or ground level access to a rental office, having walls reinforced in bathrooms so grab bars could be installed by the tenant at a later date. So if a person is needing a modification that should have already been in the unit because of the design and construction requirements under the Fair Housing Act, there may be an argument that the landlord has to pay for it. And the design and construction requirements apply to housing that was built after March of 1991. So sometimes when we're working with a client who needs a modification, we'll find out, well, when was the property built? And if what the person needs is one of those features that should have been built or included in the first place, we may have an argument that the housing provider needs to pay for it because it should have already been there. But that's going to be a case-by-case analysis. And, for the most part, it seems like properties are being developed with following these requirements, but sometimes we find that they have not been. All right, so now we are going to get into the nuts and bolts of asking for a reasonable accommodation or a reasonable modification. So the important thing to know is that you don't have to use specific magic words to ask for one. Maybe you don't remember or know to ask for a reasonable accommodation, but you're asking your landlord, I have I have an assistance animal and I need an exception to the pet rule. And the landlord can't come back and say, you didn't use the words reasonable accommodation, so I don't have to agree to anything. It can be oral or written, and a landlord can't require you to use specific forms before they'll consider your request. But we say we're talking about best practices and what we advise people to do, who need accommodations or who are having trouble getting accommodations. Make that request in writing. Even though you don't have to, it's always best to do it in writing, because then you have, and make a copy of it or take a picture of what you've requested, because then you have proof of what you've asked for, and your landlord has a better understanding of what you've asked for. And if possible, explicitly use those words that you're asking for a reasonable accommodation or a reasonable modification under the Fair Housing Act. And we'll get more into this in a minute, but if you have a disability that is not known or obvious, if it's not something that the landlord, by looking at you, is not going to know that you have this disability, then it's going to be important to get some documentation from your medical provider to support your request. And we call those a disability verification letter. We're going to get more into what that means exactly. But these are some things that are best practices. If you think you need an accommodation, go ahead and put it in writing, state that it's an accommodation, reasonable accommodation, and go ahead and work on getting that documentation from your medical provider to support your request. So we're going to talk about breaking down what to put in your reasonable accommodation letter. So sometimes we have people who are asking about how to write one on behalf of somebody else. So it's important that if you are writing an accommodation request for somebody else, be sure to explain your relationship to the person with a disability in your letter to start out with, just so the landlord or the housing provider understands who you are and why you are, engaging on behalf of their tenant. And you want to state that the person has a disability. Now, like I said earlier, a landlord, when a person is applying for housing, a landlord shouldn't be asking if you have a disability or what your disability is. But if you're asking for an accommodation, you do need to disclose that you have a disability. You don't have to disclose your diagnosis, or you don't have to give medical records about your treatment, but you do have to establish that you are a person with a disability, because you have to meet that definition of disability under the Fair Housing Act. And so what you should do is state that you are a person with a disability, and to explain that how your disability impacts major life activities. What limitations does your disability cause that is leading to you needing this accommodation? So, for example, if you are asking for an accommodation for a assigned parking space, you would say, I have a mobility limitation that is limiting my ability to walk from the parking lot to my front door. So you're not explaining your exact diagnosis. You're just saying, I have a disability and this is how it limits me, and this is what the connection is to my accommodation request. You want to be clear about what you're asking for. So continuing with the parking space example, I am asking that you give me an assigned parking space that is in front of my apartment. So, or you might even ask, like, paint the number of my apartment complex on that spot so people can't park there. Clearly state what you're asking for so the landlord has a clear understanding what you're going for, and explain how it's necessary and related to your disability. Now, sometimes it might be obvious. If you've already told the landlord, I have a physical disability that limits my ability to walk and I use a walker or a cane, then you've already explained what you're asking for is related to your disability. But if you are asking for an assistance animal, it might not be obvious, that you might say, I have a disability, I need an assistance animal, you're going to need more of a connection. I need an assistance animal because um, it helps me stay calm and be able to interact with people without getting anxious or some other explanation about that connection. And a really important thing is to ask for a response by a certain date. Now, the Fair Housing Act does not give a timeline when a landlord has to respond to a reasonable accommodation request, but they do say that landlords should reply promptly. And we find it really helpful to put a deadline for the landlord to respond when we're making accommodation requests. So that way, if you haven't heard anything by that deadline, then you know that either they're ignoring you or maybe they didn't get it, but it helps move things along. And for us, we usually say 10 days or 2 weeks is a reasonable time to respond. Now, if it's an emergency and maybe there's a eviction case going on and you need an answer more quickly, maybe you would put 5 days or some other date. But you want to put a date so that way, if you haven't heard back, you can follow up with the landlord and say, hey, I made this request. I asked you to respond by this date. I haven't heard from you. Does that mean it's denied? And so it does just help keep things moving and gives the landlord a time frame to work in. And if a landlord uh, fails to respond at all, then that may show that they're denying it, and denying a reasonable accommodation request could be a violation of the Fair Housing Act. So here's an example of a reasonable accommodation letter. As you can see, it doesn't need to be very long. It's pretty simple and straightforward. And so in this case, we have Sue Smith, and she says she's explaining where she lives, apartment B35 at Rosewood Apartments. She has a physical disability that impacts her mobility. She uses a rollator, and she has a disability parking placard. She needs an accessible parking space near the entrance of her unit. And she's asking that you modify the parking rules and provide her with a reserved parking space as a reasonable accommodation under the Fair Housing Act. So she's used those words, reasonable accommodation, reference the Fair Housing Act. Now, I have in italics attached as a letter from my doctor about my disability and a copy of my disability parking placard. I mean, if the landlord already knows about her physical disability, if the landlord has seen her using the cane and the rollator and, walking very slowly, then you may not need to provide this additional documentation to establish what is known and obvious to the landlord. But if you already have that documentation, especially a picture of the parking placard, you might as well go ahead and include it just to keep things moving along. But I did put this in italics because a person shouldn't have to provide documentation about what a landlord already knows about. And it's important to know that because sometimes, unfortunately, we've seen landlords asking for a bunch of documentation that slows down the process when they already know that the person has a obvious and visible disability. And here we have Miss Sue Smith requesting a response within 10 days. That's that reasonable time frame. And thanking them for their consideration. So again, it's a very simple request. It doesn't have to be long or detailed. She's not getting into diagnoses. She's just simply stating that she has a disability, how it impacts her daily living, it impacts her mobility, and what she needs, and asking for a response. All right, so now we're going to move into circumstances where a person needs something from a medical professional to support their reasonable accommodation request, and what sort of information is helpful to include in those letters. So first of all, these letters are usually written by a doctor or a therapist or a nurse practitioner or any person who is treating the person with a disability for whatever symptoms they have or conditions they have that are related to the person's accommodation request. And so it's really helpful for these letters to start out with explaining the relationship between the person who's writing the letter and the patient. So in this example, I have treated John for the past 2 years and I'm thoroughly familiar with his medical history. Again, it doesn't need to be long, but it's a helpful way to establish that this is a person who is your doctor who is treating you. They already know about your medical needs and they have a professional opinion to share about it. And this is good to know and helpful to know because sometimes, unfortunately, there are people who will, get someone that is not really treating them, or they'll find someone online to write these letters for an accommodation request. And a landlord doesn't have to accept documentation if it doesn't seem like that the person who is writing it is someone who is actually treating that person. And so having your established medical provider go ahead and state clearly how long they've been treating you can be really helpful to establish credibility. Um, and then the letter can go on to verify that the person has a disability that is substantially limiting one or more major life activity. So again, they don't have to share a diagnosis. Now, if a tenant or a resident or a homeowner doesn't have a problem, is okay with that diagnosis being shared, that's fine. It's the important thing is that it's the person with the diagnosis, it's their information to share, not the landlord's information to ask for. So the doctor can either share the diagnosis if the tenant is okay with that, or they can explain that the person has a disability that impacts a major life activity and explain what that major life activity is. So here in our example, Mary has a disability that makes it difficult for her to walk and leaves her unable to carry items such as a bag of groceries or a basket of laundry more than 20 feet. So that's explaining that she has a physical disability. It impacts her major life activity of walking, and the connection of what and how it's impacting her housing. So then describe what the accommodation is needed. So usually a person has talked to their doctor and said, I need this accommodation at my home. I need an assigned parking space. I'm having trouble getting one. And so the doctor ideally will put in the letter, in my medical opinion, I think that Mary needs a assigned parking space because of her limited mobility. Um, and and then that it's necessary. You want to establish that it's necessary, not just something that would be convenient or nice, but it is necessary for medical reasons. So another example here, my opinion as Jim's mental health therapist is that he requires an assistance animal to keep him company and provide him the emotional and psychological support he needs in order to live by himself in an apartment. And then the relationship between the disability and the accommodation you're asking for. Um, explain that if it's not obvious. Usually you've already covered that by if you have these previous things, but if there's any issue with establishing that there's a connection between what you're asking for and the disability, you just want to make sure that the doctor is helping you make that connection. A little bit about the format of these letters, having your doctor put that, or the medical provider, put that letter on their letterhead is really important, including a date, having them sign it. So these are all helpful because sometimes we see letters from doctors that are emailed, which is not a problem, but it sometimes makes it unclear if it's an official document. It can be easy to fake an email, but something that has the letterhead and the signature is really helpful to establish that this is a real doctor's letter. And sometimes a person might be having someone who's working with them or helping them get this paperwork together. And so if you're working with somebody to get an accommodation request, doctors are busy people. Sometimes they're like, I don't know what to write, or I don't have time to figure out what to write in these. And so it's okay to draft a letter, and ask if your doctor will review it and correct it and sign it if it's correct. But it's important that the doctor has to review it and agree to it and sign off on it. But sometimes we do help write these doctor's letters or medical provider letters, just to clearly state what is needed, because we know that medical providers can be busy people. So here's another example of a verification letter. Again, it doesn't have to be long or complicated. It's pretty simple. Dear, it would be on the letterhead, but you address it to the landlord and you have the name of the patient, and that person has been in my care since 2 years ago. I'm thoroughly familiar with his medical history and with the substantial functional limitations of his disability due to a mental health disability. Mr. Jones has certain limitations regarding social interactions, and in order to alleviate these and enhance his ability to live independently and to use and enjoy his rental unit, I am prescribing an assistance animal that will assist Mr. Jones in coping with his disability. So very simple, straightforward. It doesn't have to have a lot of detail or information. It's just a simple statement that the person has a disability, how that disability impacts their major life functions, and what they are asking for, and that connection between the request. So the request is for the assistance animal, and that's going to help Mr. Jones live independently, and cope with his disability. Again, pretty straightforward. Interactive process. So we're getting kind of into what if what if a landlord is pushing back on a reasonable accommodation request or asking for more information. So first of all, sometimes we have people who ask for an accommodation, but the landlord doesn't think that they have enough information to evaluate the request. So maybe a person, it says, I need an assistance animal because I'm disabled. And the Fair Housing Act says you have to grant this. Well, if a landlord says, I need more information, I need something from your doctor, can you get me that information? Or can you have your doctor fill out this form? That's part of the interactive process, going back and forth to establish that the tenant needs and qualifies for the accommodation request and provides sufficient information for the landlord to approve it. Another thing that can come up in an interactive process is that sometimes a person, what they ask for might not be reasonable, or it might be an undue burden to the landlord. It might be very expensive and it might cause a lot of administration burdens on the landlord. And that should not stop the conversation. There should be an ongoing discussion about what would be reasonable for a tenant, or what accommodation could still meet the tenant's needs that perhaps is not the undue financial and administrative burden. So that's what we're talking about when we're talking about the interactive process. And if a tenant is applying for a reasonable accommodation and they get denied, the tenant should try to ask the landlord, what more information do you need? Or is there another, what about this other alternative accommodation if it's something that would meet the tenant's needs? But the HUD has said in their joint statement about reasonable modifications that housing providers should be aware that persons with disabilities typically have the most accurate knowledge about the functional limitations posed by their disability. So it's important to know that usually the person with the disability does know what is most useful for them. And typically what they're asking for is not something that they're asking for because they're, just have nothing better to do, but it is something that's necessary. And so just to be clear, in the HUD Department of Justice joint statement that talks about reasonable modifications, it does have this language that, sometimes landlords, especially with modifications, they may have aesthetic concerns about a ramp or something. But if that's what the person really needs because of their functional limitations, then a landlord should grant it unless there's some really good reason not to. We've already talked about this, but again, you just want to make sure you provide proof of disability and that connection between what you're asking for and the disability. And so a landlord can ask for this if a tenant has not provided that information in the first place. All right, so when can a reasonable accommodation request be denied? First of all, if a person is not disabled, it could be denied. You do have to be disabled or meet that definition of disability under the Fair Housing Act to get an accommodation. There's no accommodations for people based on their religion in housing or based on their sex, but it only applies to people based on disability. And you have to meet, those requirements. You have to show the necessity between what you're asking for and your disability. And finally, it has to be reasonable. And so here we're talking about how HUD has defined what is reasonable. And so one is if it's a fundamental alteration in the nature of the service or program or activity. So if a tenant who has a disability and has limited mobility is asking the landlord for transportation services to the grocery store because they're not able to drive due to their disability, unless transportation is something that the landlord already provides, um, a landlord would be able to say, we don't have to approve that accommodation because that is a fundamental alteration in the nature of the services. We're housing providers, we're not transportation service providers. The main one we see, and I've mentioned it a few times, is the request creates an undue financial and administrative burden. And so if it's something that is going to be very costly for the landlord, and it's going to create a lot of extra work for the management office staff to be able to implement, in that circumstance, a landlord may argue that it is an undue financial and administrative burden. Now, sometimes a landlord thinks that if it's any sort of financial burden, if it's any cost, they don't have to grant it. But the language says undue. And so if there's some cost, that doesn't mean that the landlord doesn't have to grant it. It's looking at if it's undue. And it's going to be a case by case determination about what qualifies as undue. It may depend on if it's a mom and pop landlord that just own a few houses, or if it's a big corporate landlord that owns hundreds of apartments, what a undue financial burden might look like. And then finally, a reasonable accommodation request might be denied when a person presents what is called a direct threat in the Fair Housing Guidance. And the Fair Housing Act does not require a tenancy that would be a direct threat to the health or safety of others or result in substantial damage to the property of others, unless a reasonable accommodation could eliminate that threat. Um, so an example that sometimes where direct threat comes up is if a person with a disability is, has, maybe a person is not getting appropriate treatment, and because of a mental health disability, that tenant threatens another tenant or threatens someone in the property management office. And it's related to their disability. Their conduct is related to their disability, but the landlord says, I'm not going to rent to this tenant because they threatened or even, assaulted this other person. And that is a direct threat to the health or safety of others in this apartment complex. But in some circumstances, a reasonable accommodation could address that threat. So an example that we've seen sometimes is a person who has a mental health disability and has not been getting the treatment they need. They go to the office, the property management office, and they think that they are going to lose their housing or that something is, that they have a misunderstanding with the management and things go off the rails a little bit. And then the landlord is threatening to evict the person. But we might be able to show as an accommodation, this person has a disability, they need some time to get back on track with their treatment, and we need to come up with some better ways for the office to communicate with them that doesn't lead to these types of circumstances. Maybe a written request for information or an email or something else that could eliminate the threat. Now, again, the Fair Housing Act is not allowing tenants to break rules. But if a person needs an accommodation and it's a realistic accommodation that could prevent whatever is putting that person's housing at risk, sometimes there are circumstances where such a thing could benefit a tenant. But the tenant does have to agree to take those steps. And so it's an accommodation to come up with a plan to avoid a direct threat from existing. And I mentioned earlier, persons who are currently using unlawful controlled substances are not considered disabled. However, a person who is in recovery from use of controlled substances is considered a person with a disability, but they cannot be currently using. They're not covered by the definition of disability. So the final thing I wanted to talk about briefly is what happens if you've made a reasonable accommodation or modification request and it's denied. So first of all, if you made that request and orally, you went to the office and asked for it and it was denied, the first step that we would recommend is make sure you make that request in writing. And you can refer, and you should refer back to that original request you made. Hey, when I came to the office, on August 3rd, I asked if I could move to a first floor apartment because of my limited mobility. I haven't heard anything. I'm renewing that request in writing. Here's something from my doctor. Again, you want to make sure that request establishes that you meet each of the requirements for the reasonable accommodation. You want to show, you want to show that you're a person with a disability. If it's obvious, you just state I have a limited mobility. If it's something that's not obvious, you want to get that documentation from your medical provider to support that you're a person with a disability, that what you're asking for is necessary and related to your disability. And, if a landlord is coming back about why this is an undue financial and administrative burden, you can either explain why it's not, or consider a different accommodation that would meet your needs, that would not be an undue financial and administrative burden. And that goes into the next one here. If you're still having trouble, consult with an attorney. Legal Aid of North Carolina. We advise people about reasonable accommodation requests, and if a person's reasonable accommodation request has been denied, we can give advice about next steps you can take, and in some circumstances, we could provide assistance with pursuing a reasonable accommodation request or a modification request. And then another option is that if a person has experienced any type of housing discrimination under the Fair Housing Act, you can make a complaint with HUD or with the North Carolina Human Relations Commission. Sorry, that's a misprint there. And those are the offices that enforce the Fair Housing Act in North Carolina, and they will investigate your complaint. And their goal typically is to try to help the parties come to a resolution, which they call a conciliation. But if the parties are not able to reach an agreement to resolve it, they will complete an investigation and issue a finding about whether discrimination has occurred. And if HUD or the Human Relations Commission determines that there has been discrimination, then they have the option of filing a lawsuit to enforce the Fair Housing Act. So those are some options. So that is the end of what I have, and we can now go into the Q&A time.
Perfect. And so, as Hope mentioned, if you have a question, you cannot unmute in this forum. So if you have a question, you either need to type it in the Q&A box on Zoom or the comments section on Facebook. Not seeing any questions at the moment, but just going to give a few moments here to see if any do come in.
And I did want to say, we are going to be presenting monthly listen and learns about fair housing issues. So if there are other topics that you would like to learn about, please do post them in the Q&A or in the comments section, because we want to be responsive to what people want to learn about.
Okay, you can also put that information in the chat boxes as well as on the comment section, and it should produce, for those of you who are on Zoom, there is a listen learn feedback survey. If you have other topics, you can leave that there and we will get that information over to Hope's team for future Fair Housing Listen and Learns. And since I am not seeing any questions, I'm going to go ahead and say thank you to all of you for joining. Thank you so much, Hope, for that wonderful presentation. If you would like to review anything that Hope talked about, we have posted a recording of this event to our Facebook page. It will be immediately available. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. The recording will only be up there for about 30 days, and after that time, if you visit Legal Aid's page on YouTube, you can access this information at any time. If you would like to register for one of our other listen and learns, such as child custody, simple divorce, tenant rights, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their day.
Thank you.